if the person who signed the engagement letter is no longer representing Michael Yang, yet you appeared before a committee using the same authority that was signed by the person who's no longer connected?
Well, the engagement, Mr. Chairman, was way back in September 5, 2021, when that person was still connected with the company. And it's no different, Mr. Chairman, from, well, it's a corporation or it's a company. So it is only after that same entity would either revoke or inform us that there was a termination of the engagement that we will be deemed to have severed our business relationship, Mr. Chairman. But it is not a single person who is the one that we are contracting with, but the entity.
Yes, sir, but the document would say that the signature was for and in behalf of Mr. Michael Yang, not the corporation.
Correct, Mr. Chairman. That is why precisely the entity here is Mr. Michael Yang himself. The person who affixes signature on the document is his representative. If he is severed from the company, then the only one who can also revoke our engagement would be Mr. Michael Yang himself or the new representative, Mr. Chairman.
But didn't that just contradict your previous statement that it was the corporation that engaged the interpreter?
If you will take a look at the contract, Mr. Chairman, it speaks of our engagement by the Piley Holdings as well as some other corporations.
Yes, I'm looking at it, and it also specifically states that it is for the ongoing Senate Blue Ribbon Committee. This is a different committee, and this is a different house.
Again, Mr. Chairman, it is not the practice of our law firm to always be issuing out engagement letters for each and every case that we handle. Once a client comes in as a client, then automatically that client can refer additional cases without the need for a new engagement letter, Mr. Chairman.
Okay, so did he refer this matter to you, to your office? This particular committee hearing in the House?
I would think that I had been duly authorized because when there was a letter received by this committee, I asked them if I could appear, and I was given that authority, Mr. Chairman.
So you asked Mr. Michael Yang?
Not Mr. Michael Yang, Mr. Chairman, but the people from Piley Holdings.
I'm confused now. This letter is for Michael Yang. It was signed for and in behalf of Mr. Michael Yang, and not the corporation that you have been mentioning. And in fact, the subpoena was, or the invitation was for Mr. Michael Yang, not for the corporation that you just mentioned.
That is correct, Mr. Chairman. Again, if Your Honor will take a look at the letter, at the contract, it speaks of our engagement not for Mr. Yang alone, but also for the corporations mentioned therein. So when I received the letter from this committee, being counsel for Mr. Michael Yang as well as the other corporations, it was incumbent upon me to inform them of having received the letter invitation and what my instructions would be.
Again, it's very confusing because you said that it was for the corporation, and you talked with people of the corporation, but then the engagement is for and in behalf of only Mr. Michael Yang, not the corporations that you have just mentioned. And the invitation was sent for Mr. Michael Yang. You appeared for and in behalf of Mr. Michael Yang. Now, where's the authority there?
Again, let me repeat, Mr. Chairman, the letter speaks for itself on which or who our law firm represents and was engaged in that contract.
Okay, then you were here for and in behalf of Mr. Michael Yang the last time you were here, Attorney
Yes.
Fortun, correct?
Yes, Mr. Chairman.
Okay, so if the invitation was for Mr. Michael Yang, and your authority here is for and in behalf of Mr. Michael Yang, yet you just testified that before coming over, you talked to the persons of the corporation, not Mr. Michael Yang, to appear for and in behalf of them here in this hearing. So where was the conformity of Mr. Michael Yang?
The corporation individuals who I had spoken with,
Sir,
presume-
I'm referring to the invitation of Mr. Michael Yang.
That is correct, Mr. Chairman. The invitation was with Michael Yang. So necessarily, I would be speaking with the people who works with Mr. Michael Yang.
Sir, I think that's a different thing. It's the corporation, and this time we were inviting Mr. Michael Yang, not the corporation. And you said that you were present for and in behalf of Mr. Michael Yang. And as proof of that, representation, you submitted this authority. And this authority clearly speaks that it is for Mr. Michael Yang, but only signed by the person who is no longer connected with Mr. Michael Yang. And yet, prior to coming over, you said that you were conversing with the people of the corporation, not Mr. Michael Yang. So, I'm really confused, sir.
I will, Mr. Chairman, I do not wish to belabor the point. If the issue is that I am not duly authorized, then let me be so declared. I have no problem with that. I had come forward to this committee with the representation that I have been duly authorized. Under the rules of court, a lawyer is presumed to represent the person who he claims to represent unless it is otherwise revoked or declared to be not so.
That's true,
So,
sir.
my point, Mr. Chairman, right now is that if Your Honor believes that this counsel is not duly authorized for the reason that that letter is not proof that this counsel is not the representative or the counsel of Mr. Michael Young, I submit to the sound wisdom of this committee.
Sir,
So discharge me as so.
Sir, the only reason why we're trying to clear up this point was because in the previous hearing you were specifically asked if you were representing Mr. Michael Young, and if you were representing Mr. Michael Young, if you have proof that you were authorized or engaged to represent Mr. Michael Young. Both questions you answered in the affirmative that you were, and that you had proof that you were engaged, and that's why we're questioning this engagement, because it doesn't appear to be the engagement that or the authority that we were asking for. But if you're really insisting that you were authorized, sir, the question that I asked is if you were able to talk to Mr. Michael Young prior to coming over. But then again, you answered, I did not talk to Mr. Michael Young, but I talked to the people of the corporation. Because I'm trying to connect po, the issue on your authority and also the issue of the whereabouts of Mr. Michael Young, because we've been trying to get in touch with the guy. Now we've been trying to invite him over, and you keep appearing as his representative. So I hope you understand why we're really, belaboring the point, as you said.
I do understand, Mr. Chairman, and I regret if there's been any confusion because of this. Again, I'd like to clarify and I'd like to make it clear that the engagement of a law office is really just one-time thing. Very clearly from the document, it would show that this counsel had been duly engaged as counsel for Mr. Michael Young. Now, any subsequent appearances in court or in any other proceeding wherein Mr. Michael Young or the corporations that are mentioned in that engagement letter is involved, then this counsel can be duly tapped by that individual or corporation to appear on its behalf. It does not require this law office to come out with a new engagement letter because it's superfluous
Okay.
to our mind, Mr. Chairman.
Okay, so if you say that you are duly authorized by Mr. Michael Young, do you know the whereabouts of Mr. Michael Young now?
That is correct, Mr. Chairman. He's in Dubai.
He's in Dubai. And when was the last time you got in touch with Mr. Michael Young?
Per se, him, maybe 2 years ago. He is very difficult to speak with directly, Mr. Chairman. He only speaks Chinese, and this counsel does not speak Chinese.
So in representing him in this particular hearing, what were the parameters of your engagement? Did he tell you na you can only answer about this or that? Kasi it would be useless for you to appear and here and say that you were properly authorized to appear without you having been in touch with your principal and coordinated with him what possible answers you would be allowed to give to this committee.
Mr. Chairman, during the first time that I appeared about a month or a month and a half ago, I had made it very clear as well that the only reason that this counsel appeared was because the letter invitation to Mr. Michael Young was sent to our law office instead to him directly. And so I had said that out of respect for this committee, I was appearing, and the honorable committee members had taken advantage of that particular situation and asked me a number of questions, aside from asking for additional documents, which this counsel would be in a position to provide. And I, in fact, did that by providing it. So, per se, Mr. Chairman, I had done it precisely because I wanted to somehow help this committee to arrive at some information in aid of legislation that would be able to, well, at least in my personal capacity, as to being able to speak for and on behalf of Mr. Michael Young. I have regrets that I cannot do so because, to be perfectly candid, I have not spoken to him for roughly more than 2 years since the last time that there was a hearing before the Senate.
Sir, wouldn't it have been more prudent on the part of you acting as a lawyer of Mr. Michael Young to try to get in touch with him, because you've received already 2 invitations before this committee and it refers to his dealings prior to, prior to the last time you talked to him 2 years ago. So at least man lang be updated on what has been happening or the probable questions that may be asked before this committee. Because you claim that you are still representing him, that the engagement is still ongoing. So, para sa akin, parang hirap naman intindihin na hindi mo man lang kinausap. Or even if he doesn't speak English or Tagalog, I'm sure your law office could have arranged a time and a date where you could call him with an interpreter siguro. This letter clearly states. So, it's, I don't know, parang in-engage ka ng tao, yet ibang tao kausapin mo if the invitation was for that person. That's kind of hard to believe, Attorney Fortune. No, but anyway, since that's what you answered, sige, I'll leave it at that na lang.
Thank you, Mr. Chairman. Thank you.
Thank you, Congressman Flores. There are more clarifications that the committee members would ask Attorney Fortune later with regards to the engagement of his law firm to Mr. Michael Young et al. I would suppose that his company, his corporations, which he has a share on is the same law firm that he engaged, no? Your law firm.
Mr. Chair.
Yes, Mr. Chairman. I would think so.
Mr. Chairman.
So, sige, Congressman Acop,
Sige.
and then Congressman Dan Fernandez, and then we proceed with the Zoom presentation. Congressman Acop, you're recognized.
Thank you, Mr. Chair. We're talking about Mr. Michael Young. May I ask if a subpoena was issued to Mr. Michael Young?
Yes, sir. We have issued a subpoena. This was dated June 24, 2024.
Today, when he's supposed to appear pursuant to that subpoena, Mr. Young is not present.
Yes, sir.
And pursuant also to our protocols in our inquiry in aid of legislation, if a person does not appear pursuant to a subpoena, then we can move, if we have a quorum, to cite that person in contempt. Would that be correct?
I believe so, sir, according to our rules.
Mr. Chair, do we have a quorum this morning as of now?
Yes, Congressman Acop, there is a quorum. In addition to the 8 members who are present, both in Zoom and physically present in today's hearing, we have an additional member who just arrived, Congresswoman Jinky Luistro, who is also present. Therefore, the number of attendees in this committee hearing is 10 members present. Being demanded from him, since he is not present, pursuant to our rules on Section 11, if I may read, the committee may punish any person for contempt by a vote of 2/3 of the members present. We have a quorum. We have 10 members present, which is more than 2/3. And citing the violation committed by Mr. Michael Young on Section 11, Paragraph A, refusal without legal excuse to obey summons and invitation. There is a motion to cite Mr. Michael Young in contempt. And duly seconded. Hearing no objection, the committee is now citing in contempt Mr. Michael Young.
Mr. Attorney Fortuno, of his presence on our hearing anymore. Since, according to him naman, that his client, Mr. Michael Young, is not in contact with him for 2 years already. And I think Mr. Michael Young is not interested on trying to contact his lawyer. So I think the presence of Attorney Porton here is not needed at this point of time. So, Mr. Chair, I move that we excuse Attorney Porton.
Mr. Chairman.
Matter.
Okay, before we rule on that motion by Congressman Dan Fernandez, Congressman Paduano.
Thank you, Mr. Chairman. Anyway, Mr. Chairman, before I make a manifestation with regards to the statement made by Attorney Fortune. Mr. Chairman, the first motion was already approved, citing contempt Mr. Michael Young. So we have to move for another motion for how long and where to detain Mr. Michael Young. So with that, Mr. Chairman, I move that we detain Mr. Michael Young for 30 days. And same as in the case of Mayor Ponsalan, he was cited in contempt and was detained in Bicutan, Mr. Chairman. So move, Mr. Chairman.
Okay, before I rule again on that, let me dispose first of the first motion by Congressman Dan Fernandez. His motion is to excuse the counsel appearing for and on behalf of Mr. Michael Young. Since we will not be anymore asking questions to him, so there is a motion to excuse Mr. Attorney Raymond Fortune in our today's hearing. Hearing no objection, duly seconded.
Before I second the motion of Chairman Dan Fernandez, as I've said, I'll just make a short manifestation with regards to the statement made by Attorney Fortune. As I said, Mr. Chairman, Attorney Fortune is claiming to represent Michael Young, but he never talked, he never seen the subject of this investigation for 2 years. How can represent a person without talking? No. Now, the authority that was given to him, sabi niya nga, Michael Young, but of course, he talked to the members of the corporations, representing Paili Holdings Corporation. Are you at liberty of telling the, testifying this committee, who are those people in this corporation that you have submitted to us? The following group of companies, Paili Holdings Corporation, Paili State Group Corporation, and all other subsidiaries.
Mr. Chairman, I can duly inform you that the person who I tried to reach was via a cell phone, and that this is the cell phone of the legal department of Piley Holdings.
Yun na naman, legal department. Anyway, Mr. Chairman, uh, I will not be labor on that. So I second the motion of Attorney Dan Fernandez to excuse Attorney Fortune in this particular hearing.
Okay, there is a motion, duly seconded. Hearing no objection, the motion of Congressman Dan Fernandez is approved.
Thank
Now,
you, Mr. Chairman.
uh,
Permission to leave.
With respect to the, Attorney Fortune, you are excused. With respect to the motion by Congressman Paduano specifying the penalty that will be imposed on Mr. Michael Yang pursuant to our rules on Section 12, it says by a vote of 2/3 of the members present, there being a quorum, those cited under Section 11, in this case, Section 11, Paragraph A, shall be detained for a period not exceeding 10 days in a place designated by the chairperson or acting chairperson under the custody of the sergeant at arms. The pleasure of the committee is now being asked, but before we finally rule on this, if I may ask Congressman Paduano, the movant of the motion, to allow the chair to dispose your motion relative to the penalty that will be imposed on Mr. Michael Yang before we adjourn in our today's committee hearing. Would that be all right? We have a quorum. Yeah, we have a quorum. A quorum has been established, and this has.
Of course, the votes will be counted based on the votes of each individual members, Mr. Chairman. And baka po pagdating ng dulo, makawala na tayong quorum.
That is correct, Congressman Paduano. That's why we ask the members present and those in Zoom to please manifest your vote to the committee secretary. Please, Comsec, please record the votes. But we shall rule on that before we adjourn our committee hearing today. So the motion is to impose a penalty of detention at ano? For 30 days. Yeah, for 30 days at Bikutan City Jail. At Bikutan City Jail to Mr. Michael Yang.